Welcome back to the live stream, and thank you for being patient through the timer. We still have a premiere that is just finishing off, but in the meantime, I am joined once again by Mr. Alan Robertshaw. Let me make sure you are unmuted. How are you doing today, Al?
I'm really well, and again, looking forward to this. It's been confusing, so I've just been watching myself on the other video. So hang on, how am I there and here at the same time?
Indeed. Well, you are here. I can definitely see you and hear you, so that's good. And hopefully we'll be joined by those that were watching the premiere just now, so hopefully it wasn't too confusing for everybody else. That was a bit of an impromptu start by the both of us. We thought, let's do that first of all, because these headlines have been going around, so you've just watched that, so we'll not talk more about that. But Alan, you had a great idea of something to talk about for today, which is that big question: do, and if so, why do celebrities get special treatment? What do we mean by that, Al?
Well, they do. You know, we sometimes say, oh, there's one law for them and there's one law for the rest of us. When it comes to certain things, especially defamation, that is actually true. So what I thought is, because there was so much interest following on from the last video when we discussed the possible ground of appeal they would take, which was to challenge that particular Pendleton and Newsom case. And people have shown a lot of interest and said, oh, you know, what grounds? And it's actually going to be on something called, it's effectively going to be that the case in Pendleton and Newsom, it should be a different test for public figures. But because that argument is relatively straightforward and simple, and we can't pad it out that much, I'm going to go right back to the start and say, what do we mean by public figures, and how did they end up being treated differently?
Indeed.
And again, uncharacteristically, I have made some notes. I'm going to start from the English perspective, because this is the case. You know, it's a common law jurisdiction, and other common law jurisdictions sort of followed this reasoning. Sometimes they took slightly different approaches to it and branched off, but they were, you know, asking and answering the same questions. So our story dates back to where somebody he wrote a little just sketch in like a thing in Edwardian times, pre-war times. He wrote a little sort of sketch about somebody going on holiday to France, little trip to France. A chap called Artemus Jones, a completely fictional character. And he implied that Mr. Jones was going and doing improper things with the ladies. And, you know, we thought that's, you know, like a nice little article. However, there was a real Artemus Jones, who unfortunately, for the publisher of the article, was a lawyer. And he brought defamation proceedings and said, everybody's going and saying, what's this with you nipping off to France? Does the missus know about this? So he sued for defamation. And the defense was, well, I don't even know who this guy is. I've never met him before. So how can I accidentally defame somebody? You know, there has to be a mens rea element. But this went all the way up to the Supreme Court and about, you know, House of Lords back then. And said, actually, no. And there was a lot of argument about this. So there were dissenting judgments that said, actually, no, that's silly. Yeah, you can't. The whole point of a tort is you've done something wrong. And if you've done something wrong, you've done nothing wrong. Why should you be penalised for it? But the other side was, well, actually, no, because civil litigation in this country is not punitive. It's purely compensatory. This guy has suffered a loss because of something you did. He should be compensated for it. And they allowed it to go through. So this poor chap who'd written the story ended up having to pay out on his defamation claim. But there was a lot of talk afterwards, especially because, like I said, the actual appeal court had said, we're not sure, some of the appeal courts said, we're not quite sure this is right. And there was a commission put in place. And, you know, they took a little while to report back, but that produced the 1952 Defamation Act. And that brought a defence in for innocent defamation. And what it said is it wasn't a complete defence. You couldn't just sort of say it was an accident if somebody sued you. And say, you know, what you had to do is you had to raise this effectively once you knew there's a claim. So the claim comes in, instead of defending it, you do what's called an offer of amends. Or as soon as it's brought to your attention, in fact, even before a claim, somebody says, oh, you've defamed me by accident. And what you do is you say, oh, absolutely, you're absolutely right, hands up. I'm really, really sorry. I'll publish a retraction. We'll work something out. What do you need from me? And if the person accepts that, that is the end of the matter. They can actually refuse the offer of amends and go to trial and say, no, I refuse that. Your offer of amends is inadequate. I will go to trial on this. The courts, though, then even say, well, yeah, you were defamed. It's like, well, look, you know, what are you actually seeking to achieve here? The offer of amends would probably have sorted it. So unless realistically the offer of offence was seen some way as inadequate, they probably wouldn't even award that many damages. Now, as it happens, in the 1996 Defamation Act, they expanded this idea of offer of amends to just any defamation. So even if you had been reckless or negligent or intentional, you could come back and say, okay, hands up, you've got me. I want to sort this out now. And you can make the same offer of amends. And interestingly, when they did that, they sort of abolished the defence of innocent defamation and they just wrapped it all up in this one procedure. And the one slight difference here is you make the offer of amends. There is still a court hearing where a judge will say, actually, you've done that, but I'm still going to look at the damages element. Now, if it was a completely innocent defamation, they might say, well, realistically, what damages are there? But bearing in mind, like I say, it's compensatory, not punitive. But the fact that somebody instantly held their hands up, were as prominent in the retraction as they were in the original article, really tried to bring it to everybody's attention, that would obviously have an effect on damages, because how much is your reputation harmed if a mistake was corrected early? So that's the procedure. It used to be capped at £10,000 if you made an offer of amends. Now, technically, it's not. But it's always a lot lower. The damage is always a lot lower if you've made an offer of amends, even if it's been refused. So it's always tactically a wise thing to do.
It's a show of good faith.
Yeah, but that basically established the precedent that the mens rea element. And when we say mens rea, more Latin, what were you thinking at the time?
Mm-hmm. Where was the intention? What did you intend to do?
Yeah, there was no malice element in defamation at that time. If you just defamed somebody and you didn't have a defence like qualified privilege or parliamentary privilege, where that they provide defences themselves, and some of them are what we call qualified privilege. Mm-hmm. So if, say, for instance, I'm in a situation, classic example, a job reference. Somebody says, can you give a job reference? I write the job reference. And it turns out to be defamatory. There's something in there that's incorrect. Because I'm not just spreading gossip, I was specifically asked, and the test is whether you had a duty to provide the information or the person you gave it to had a legitimate interest in receiving that information. If that situation is there and you actually defame somebody, then you have to show malice. But generally speaking, if it's just straight defamation, you don't have to show malice. It's just that, you've made a false statement and effectively it's somebody has suffered a loss from it. So we carry on with that. Now, there was a case, and I've actually done, I don't know if we've gone to bring all these up.
Sure.
In the US, they had the same test. I'm going to flip across to the Atlantic now, just to sort of bring our American friends. Somebody defamed a politician. They published an article that was clearly not true, so that person sued for defamation. However, the court said, look, in terms of politics, first of all, you stick your head above the parapet by volunteering to, take power. But also, people have a legitimate interest in commenting on, people who are in positions of power. And we don't want to put too chilling an effect on them doing that. There is a legitimate reason for them to sort of talk. And gossip can be okay because, Caesar's wife must be above suspicion. So politicians have to, expect basically people to talk about them and not always check their facts. So that introduced what we call the public official standard. So public officials could only sue for defamation if it was shown that somebody was deliberately defaming them or they hadn't carried out effectively, due diligence, if they were reckless. And that's the whole, that's the malice thing again that we had in that recent trial. And depending on who you are. I mean, back in those days, they weren't, your citizen journalists as much. It was just like ordinary newspapers. So they put a particular standard on them, check your sources, maybe get in touch with the other person, see what they have to say about it. So that became the test. Okay, so that just applied to public officials. Later on, though, there was another case, and it was a baseball coach, and people commented about, his times as a baseball coach, and again made some quite defamatory allegations. And he sued. And he said, well, you're always in the newspapers. This is a matter of legitimate public interest. We're going to talk about you. He said, well, no, I'm just a private citizen. I'm not a public official. I don't have any powers over anybody. So, this is just my job. However, the court, and I think this is an interesting one, they said, actually, no, you're in the public eye. You're voluntarily in the public eye. People are allowed to comment on you. It's part of your job being a baseball coach. People are going, people are going to be in bars chatting about you. People are going to be writing in the sports pages about everything you've done. So you just have to live with it. So The you must prove malice test now applies in the US law to public figures. And remember, that was one of the elements they had to show in that trial, because
what trial was that, Al?
I don't know. There was one in the paper. I keep forgetting about it. I think I can't remember. I think it was something to do with Rachel Ryler or some footballers. Anyway, so basically they introduced that test there, and that's why when Amber Heard said, 2 years ago I became a public figure. It's like, well, you've admitted you're a public figure, and it seems Depp didn't really challenge it. However, the public figure thing, it's only in relation to your public persona. So say, for instance, the baseball coach. So, anything to do with his baseball coaching, you're corrupt, you're taking bribes, you're rubbish, I say, you're throwing games. That's legit stuff. But, something completely unrelated. I mean, maybe, you fiddle your taxes. I don't know, that might be something for a baseball, coach. But if it was something completely unrelated, to say, actually, in that respect, you are not a public figure. And they actually call it limited issue public figures. The classic example is, and this is something that never came up in the Alex Jones case, would those parents have been public figures? Because in all fairness, they were going out on the news and talking. But the courts recognise that you can be, unintentional public figures, if you're a victim of a crime, for instance. And they, again, apply a slightly different threshold there, because, it's not like you deliberately stuck your head above the parapet. But if you go out there and hold yourself up as, I am talking on behalf of the public, or I am making a point on behalf of a particular group of society, or I am raising an issue of legitimate public interest, the court say, within that sphere, you are to be regarded as a public figure, and anything anybody comments about you that's directly related to that, you have to prove the malice standard. If it's something unrelated to that, it's just straightforward defamation. Okay, so we now skip back across the Atlantic to the UK, because people are going, what happens in England and Wales, Al? Because we like blogging. There's a case about Derbyshire Council, and somebody said, Derbyshire Council, bunch of corrupt, useless, etc., etc., etc. So the council sued. And here's what's interesting. The court said, no, public bodies in England and Wales cannot sue for defamation, because it's the same thing. You're in the public arena, you've put your head above the parapet, and you have power over people. They are allowed to speculate about you and gossip about you. However, unlike in the US, where individual politicians are public figures, they said, no, this does not apply to individuals. So it's perfectly okay to say my local parish council is corrupt. What you cannot say is councillors Smith, Jones and Bloggs are corrupt. Okay? I mean, it's this whole thing. It's in a similar way where, you can't defame a group at large, and how large that group is a matter of fact. There was if you remember that New Statesman programme with Rick Mayall, they had to change a line in there because they'd said somebody was the biggest something defamatory in the cabinet. And because the cabinet's relatively small, the BBC, whichever lawyers it was, whichever TV company said, no, change it to the government. He's the biggest X in the government. Because
and there's some tests there as well, aren't there, Al? Because if you're looking at a group, then, as you say, if the group's sufficiently large, you can't possibly know who it is. But if let's say only one of them went to a particular school and was part of a particular football team and was driving a particular car, even though it's part of a group, well, if you said everybody that went to this school and did this and did that within this group, then quite clearly people can know who you're talking about.
Yeah, so that's the whole thing. You can say all lawyers are corrupt. You can't say all lawyers at X firm are corrupt. Okay, that's the test there. But when it's public body, then it's a free for all. No matter how small that public body is, your village council might be like one guy and his cat. But as long as you refer to it as a village council, you're probably. I mean, don't forget, I'm in Cornwall, where the deputy chief constable of Scilly was a cat for quite a while. So that's
I was going to say possibly is one person in a hut with a cat.
He's got more Facebook followers than I have. But in all fairness, he's a very hard-working cat. It's great on Scilly because the Scilly police just post stuff where they just go, there was a crime the other night where something got nicked. If it's back at the station by lunchtime, we'll say no more about it. It's a very, very laissez-faire approach to crime. Seriously, check out their Facebook page. It's fantastic. It's all stuff like that. Like, please bring that back.
Well, I do just at a pause there, because I've had a lot of questions about this vis-a-vis defamation and publication and private, private issues and all that sort of stuff. But people are talking about, can you defame somebody when, let's say, you've got, dash cam footage or something that's in public and therefore is put in the public domain, and a bit like the Ashley Neal video we were talking about, could you defame the driver? Well, you don't know who the driver was. No one knew who the driver was. there's lots of people, just as the tangent for people, really to direct people if you're interested in this kind of stuff, that we've done it's about an hour long video about this very issue, about dash cam footage. And following on from that, there were lots of questions about defamation, about if you're putting this footage out in the public and commenting on it, can you defame somebody? Well, of course, yes, potentially, can't you, Al? But if you're sort of backing it up with your opinion, you're giving people the opportunity to watch the video, comment on the video, see it for themselves, disagree with you if necessary, and all of that comes into play, doesn't it?
We said all these things about, no, it'll be absolutely fine, because although at first glance it's a chase level 1 statement, i.e. somebody definitely did something, the fact that you can see what they're commenting on yourself and come to a different conclusion would take the sting out of that. And I was going, that is definitely an interpretation of the law. And then luckily, like the week after, there was that sort of Riley and Murray case where they said that she lost that case and said all you needed to do was screenshot the tweet you're commenting on. And even though what you said is completely unarguable, people could have seen this tweet themselves and gone, she's talking nonsense. Yeah. So it's not defamatory. So yeah, I was quite glad about that. But if you are ever going to comment on anything, and this is the same whether it's a matter of opinion, which is a defence to defamation, but again, it's not. There is a test to that, or whether it's public interest. We'll come on to that in a moment, I think. Make sure you refer to what you're commenting on and why you have come to your conclusion, because opinion has to be based on facts. You have to be saying, well, based on these facts, my opinion is X. But what if those facts turn out not to be true? Well, it depends. If at the time it was reasonable for you to believe they were true, you're probably okay. But if it was either completely unreasonable for you to believe on those, or the situation changes and you don't take an opportunity to correct that, then that can be defamatory then, because your opinion isn't based on true facts, or at least facts you thought were true at the time. So, this is something, and it's the same with public interest, and perhaps we'll come on to that, because, as I'm saying, in England and Wales, we don't treat public people differently from private people. However, we have this public interest test. It's a defence to a defamation claim to show, and people get confused because it's actually a 2-part test, but it's not expressed very well. It's got to be on a subject that is a matter of legitimate public interest, which again we keep saying is not the same as of interest to the public. But also the publication has to be in the public interest. So it's a 2-part test. So say, for instance, it's an allegation of somebody's fiddling their taxes. And you don't really have any evidence. It's a bit of gossip that you picked up, that it's like, I've heard this. And you say, so-and-so is fiddling their taxes. Well, what if it's Joe Bloggs down the road and he sues you for defamation? So, well, look, people not paying their taxes is a matter of legitimate public interest. And the court might say, yeah, it is. However, it wasn't in the public interest for you to publish that because you didn't know enough information. There are other alternatives too. You could have just reported him to the revenue. That was your remedy there. Or you could have actually asked his opinion. Hey, Joe, I just want to check this out before I go on Facebook. What's your tax affairs like? However, if, say, somebody was standing for elected office, and I say this because this actually cropped up, a certain person who was standing for, in the PM election, people were questioning their tax affairs, and they sent out a letter. We should do a little thing on that, because I think that letter, and I'm saying this in my opinion, that letter really pushed the line as to what is appropriate for lawyers to be sending. Okay, but in my opinion, other people might say, no, that's fine, that's fine. Yeah. But had that person sued, could they have raised the public? And somebody said, could they raise the public interest defence as a defence in that case? Well, possibly so, because we've agreed people not paying their taxes is a legitimate, matter of legitimate public interest, but all the more so for somebody who's effectively going to be in charge of, the economy. But was it in the public interest to publish? Well, actually, yeah, because it's more important. This is something that is really, really important. Now, you could report to the revenue, but who cares? And what if you reach out for comment? Well, if somebody's like a busy person like that, are they even going to respond to you? Why even bother? If you're the Times and you sort of write to the Cabinet Press Office or, say, could you, we're going to publish this story, does he want to comment? That might be different. Me just sending a tweet out going, I'm about to say something really bad about you on Twitter. Do you want to chip in? Well, it depends. If it's somebody who I'm just chatting with Twitter on, they might say yes. If it's a huge celebrity with 1 billion followers, they're not going to get back to me, so why bother? All these things turn on their facts. But what I'm saying is there might be a bit of a backdoor sort of public figure defence. Because again, you know, you can defeat public interest if you show it wasn't reasonable. You know, effectively, if it's malice, if it wasn't a sort of honestly held opinion, if it wasn't really a matter of public interest, if you were publishing. Even, I mean, it can be as fair as defence if they can say, well, somebody could have published this in the public interest, but you didn't. You just did it as part of your harassment campaign or something like that. That might defeat the defence. But there you go. So when we do say there's one law for them and one law for the rest of us, this all comes in. And also it crops up in privacy. And there's quite an overlap between privacy and defamation.
Indeed.
There's some important distinctions. Say you find out somebody's going to publish a story about you and it's not true. You can't get an injunction. There's no prior restraint. However, what if someone's going to breach a confidence about you? Some secrets,
That's what I was just going to come on to, actually. I was just going to prompt up about breach of confidence, because there's a lot of discussion about that. So, I mean, what is confidence and what is a breach of confidence? What is in confidence? Well, there's tests for it. It's got to be something that has what we call the necessary quality of confidence about it. So, a chat with the person in the street doesn't really have much of a nature of confidence about it or quality of confidence about it. But what about a chat with your lawyer about a potential prosecution? Let's say, you're being questioned by the police, and then you take a lawyer's advice. What if they do charge me? Where do I stand? And actually, I did this, but I didn't think it was that. And quite obviously, there's a nature and quality of confidence about that. And so if you then went off to confide in a friend and say, do you know what, I'm in a spot of bother, I've spoken to the police, and then I've got a lawyer, and the lawyer's told me this, what do you think? What do you, as a reasonable person, what do you think? And even if you didn't expressly say, don't tell anybody, don't go away and tell anybody, there is a quality of confidence about that conversation. If they went off to the papers and spilled it and sold it for whatever the going rate is today, £700-800, I don't know what they sell the stories to the papers for these days, but it's probably about right, isn't it? But par for a substandard story. But anyway, that's probably a breach of confidence, because there's a quality of confidence about it. And so that, as you were about to say, Al, that overlaps with defamation, because if that's
It's an interesting one, because you can have contractual confidence as well. It's not uncommon in employment contracts to sort of say, you can't speak about sort of, commercial secrets. Then you've got into all this public interest disclosure, which is a topic for another day. But let's say confidence.
There's another myth. Just sorry to cut across you, but there's another myth that just sort of popped up in my head when you talk about providing references, and there's all sorts of myths. As it's like either an offence to provide a wrong reference, or a criminal offence to refuse to provide a reference, and all of this sort of stuff. And you've mentioned that there is almost a duty to provide some kind of reference, because if you've been the employer and they come to you and say, well, hey, look, can I trust this person? And really the only rule is you've got to be honest, right? And it's no sort of offense to say, well, actually, to be honest, they didn't really turn up on time, work was a bit substandard, nice person, but whatever, that was about it. There's not really anything wrong with that, so long as it's the truth, and you've got your own records and whatever, you can back it up. But again, overlaps with what you're about to say, Al, which is that can move over to defamation.
Yeah, because let's say somebody, somebody's going to breach some, leak some secret information, some confidential information. Now, in that case, you can get an injunction, because the whole point is, and we've discussed this in relation to sort of, in previous videos, the cat would be out of the bag. Once the cat's out of the bag, an injunction is pointless. So a court will generally, if you can sort of show even a prima facie case that the material is confidential, it's relatively simple to get an injunction in that case, because when we apply for injunctions, and we're going off at a tangent, but people like this, because and this applies to all injunctions. You want to stop your neighbour cutting down a tree, or your non-molestation orders. There's a test. It's called the American cyanamide test after a case. And it's quite funny. Once a friend she rang me in desperation because a judge, she was going for an injunction. An injunction had cropped up in a case, and she wasn't expecting it. It's in an area she doesn't normally practice. She said, the judge has just said, I want you to address me on American cyanamide. And I have no idea what that is. So he's let me come out for lunch. He wants me back at 2. And so what do I tell him? And I said, American Cyanamide is the company that used to make Allspice. And she went, that's not really helpful. So then I told her the information I'm about to tell you, which is, first of all, to apply for an injunction, you've got to show there's a cause of action. So if you want to stop somebody cutting down a tree and it's about to fall on your house, that could be sort of negligence or trespass to property. If you want to stop somebody talking about you, that's breach of confidence. If you want to stop somebody going to work for somebody else, that could be a breach of contract. So you've got to show there's a cause of action, and you've also got to, if you've not issued, you've got to say, I give an undertaking to issue proceedings in this. Because sometimes you can literally do this on the phone if it's an emergency. Hey judge, this is what's happening. I need you to give me an injunction. I'll get all the paperwork in. You give an undertaking to get the paperwork in. Usually, though, you'll try and at least scroll some sort of statement in and get it from them. So you say, first of all, there's a cause of action. Then you have to say, damages is not an appropriate remedy. So say, for instance, you say, well, look, if this goes ahead and they do this and it turns out they shouldn't have done, I'll be way out of pocket. You say, well, that's all right, then you just sue them for the money. Yeah,
and just pause on that. I think this is certainly a lot of people I've spoken to really don't get this point, especially when I'm advising on the prospects of an injunction or defending an injunction application. Damages as a suitable remedy. So let's look at this from a point of view of what we've always said before is when you go to court, you're asking the court to make a decision. Whether that's a criminal one or a civil one, you're asking the court to make a decision. Either, find someone guilty, not guilty, or in a civil trial, to award damages. Who's right, who's wrong, broadly speaking, and who deserves the money. The injunction applications are very different to that in that you're asking the court to interfere effectively in somebody's sort of rights and freedoms, but not in a criminal sense, in a civil sense, which is more than civil, but it's not as much as criminal, but it therefore has to have its test. You're asking the court to order someone either to do something, a mandatory injunction, or don't do something, a prohibitory injunction. And there's a third, which is kind of rare, to quia timid, which is a bit almost like you're afraid that something's going to happen. It's very difficult to explain. But three broadly types of injunction. You're asking the court to interfere with what is otherwise somebody's ordinary course of dealings. And so the court's slow to do that. And unless there's sort of very good reasons, it's normally urgent, because otherwise, if it's going to happen next year, then you could probably resolve the issues by then anyway. But also, as the point that Al just mentioned about damages as a suitable remedy, if money can sort it out, then it doesn't matter. You can just go to trial and at the end sort it out at the end. If you're going to lose out on £5,000 or dollars. And if it's not granted and it turns out that it should have been granted and so on, if 5,000 would sort it out, well, we'll deal with it at the end then. But if it's to compare that with cutting a tree down and someone's about to cut a tree down that they don't own, it's your tree and you don't want them to cut it down, or the other way around, that it's about to fall down and smash your house in and you want it taken down and they don't want to take it down, so it's either take it down, not take it down. Money's not going to resolve that necessarily either way, is it? So if money is not, i.e. damages is not a sufficient remedy, then that's one of the considerations for an injunction. I thought that's just worth chipping in with.
Because obviously they said damages is not an appropriate remedy. Now, obviously, if you didn't have the injunction, if something's happened to you, because a classic word, personal injury is a good ground to get an injunction on. If somebody does this activity, I am at risk of personal injury. Now, of course, we do award damages for personal injury, and we say we have compensated for you. An exercise we use is somebody trying to stop a golf competition because it will encourage golfers to shoot across somebody's land, and their cat might get hit, or they might get hit. And even though you could compensate for that, they say, well, naturally, no, we're not going to say, look, if you do get injured, we'll get them to pay you some cash. It is considered that although damages are available, they're not an appropriate remedy.
Yeah, it'd be a little bit perverse, wouldn't it? They might do this and they might, kill my pet. Well, if they do that, we'll sort some money out afterwards. It's not quite the way. That's not the appropriate way a court wants to look at it. So if it can prevent that from happening, then that's more likely to be suitable.
Yeah. Now, the next thing they consider is what we call the balance of convenience. And perhaps an easier way is to look at it from the reverse. The test is, let's say, whoever I say wins today, whether you get your injunction or you don't, let's say I'm wrong, who would lose out the most, depending on which decision? So you basically go, let's assume I don't make this injunction, and it turns out I should have made this injunction, the claimant will suffer this amount of damage. Now, let's say I do make this injunction, and it turns out I shouldn't have made this injunction, the defendant will suffer this amount of damage. And they look at who would suffer the most, and they go with the least harm. Okay? So that's the balance of convenience test. If I get this wrong, how big a mistake have I made, basically, is the
it's
test.
also thought of as trying to keep the status quo as much as possible. So, again, as Al said, I think I like the scales analogy because it's hand in hand with justice, isn't it?
I've done that in a hearing.
Yeah. I think I've probably done something similar. It's hand in hand with the scales of justice. I always like to say that if you hear one side of a case, you should be absolutely convinced that side is right. But then you hear the other side and you're equally convinced. And then you're supposed to be at the end. The judge or the jury are supposed to be at the end, like, literally, let's weigh this up. And it's a bit like that with the injunction tests and the balance of convenience or keeping the status quo. So how much can you keep the status quo? And it as Al said, it depends which party is going to suffer the most. If one is going to absolutely suffer, let's say you wanted, I don't know, let's say you've had an ex-employee disappear with a laptop with all the firm's secrets on it and databases and all of this sort of stuff, and you want the court to order it up or whatever. But let's say some time has passed, and so initially, right at the beginning, that would have been a really hot thing. You've got to get it back now because it's brand new information. But let's say a year goes by, and now the information is not so new anymore, but the person's kept using it, and their personal information's on it, and they are using it actively, and they would suffer quite a lot actually because it's like their day-to-day laptop, whereas the company doesn't really need it back by that point. This is the balancing exercise the court will go through, and so those are the arguments that need to be weighed up. You can see quite quickly there that that's a difficult argument.
Yeah, I mean it's fairly logical test. Like I say, I mean I'll get back to the confidentiality thing because the classic example is confidentiality on the balance of convenience. It's either, well, unless there's a pressing need to get this information out, it can keep. I mean, we do recognise that information is a perishable commodity, but let's say it's to stop a story going out. Look, it's going to make no difference to this newspaper if you publish it tomorrow or next week. Whereas if I get this wrong and the information does go out, and it turns out I shouldn't have let the information out, this poor person, there's no way of getting the cat back in the bag. So that's also very easy. That's why confidentiality injunctions are relatively easy to get. One final point is, like we've said, if the court makes the injunction and it turns out they shouldn't have made the injunction and the other side suffers damage, you must give a cross undertaking to say, yeah, if it turns out the injunction was made incorrectly and they suffer loss, I will compensate them for that and they don't have to issue a claim against me. Now, they have moved on a little bit from that because they've recognised that can be quite a harsh test because effectively it puts a financial test. Somebody might have a fantastically good reason for getting an injunction up against like a huge organisation, but they're just an impoverished person. Mm-hmm. Then they say, well, actually, do you know what? Sometimes big companies just have to take the hit on the fact that they sometimes lose money. They can afford it. I mean, there's a classic case on that where it was to stop an aeroplane flying off because if this aeroplane had flown off out of the jurisdiction, somebody lost a personal injury claim. And they said, well, we're not stopping it because he can't compensate us for all the millions of dollars we lose by not flying this flight. And they said, this is just some guy, I think, running over the aeroplane or something. And they said, look, no, we are not stopping, you escaping this possibly serious negligence claim just because he can't afford to compensate from some flights. You can afford to take the risk on that one.
Yeah, so this cross undertaking again is something a lot of people struggle with. It's at first blush, at least, a difficult thing to get your head around, even like as a law student, for example. But a cross undertaking. So effectively, the reason essentially is because when you go for an injunction, it's very often what we call without notice or ex parte, or in other words, you're arguing by yourself without the other side turning up and being there to argue against you, at least at first. So because they're not there, there's two things apply. You've got a full and frank disclosure. So as you've said before, you've got to somewhat make the arguments for the other side or what they would have made had they been there. And also all of the information that they might have available. Well, they might be able to show this, but on balance, we still argue whatever. And at the same time, this cross undertaking. In other words, I want an injunction. If I'm wrong, fine, I'll compensate them for it. I'll undertake or indemnify their losses for the injunction that's made that shouldn't have been made if I'm wrong. And so it's almost a show of faith, isn't it, that if you're definitely right in your application for injunction and you're being full and frank and honest and showing everything to the court to decide this on, and then you'll say, yep, fine, I'll undertake to cover their damages if I'm wrong, then it's part and parcel. But it is quite strict, quite harsh.
Yeah, but so that's effectively the test. And just to get back, when I told my friend all this, and actually I did get a call about 4:00 where she'd got her injunction. So now, she said, yeah, she said, did that, I got the injunction. And she said, actually, at the end, I did chip in and say, oh, by the way, they're the company that make Allspice. And so that was the thing the judge was most interested in because he knew the American cyanamide test. And this is the thing, when we go to court, you always sort of go, I'll address you on the American cyanamide point. But if it's a judge deals with injunctions day in, day out, you can literally just go in and say, look, here's the situation. If you don't give us this injunction, this is going to happen. If you do give us this injunction, the worst that can happen to them is that we're good for the money and we promise we'll sue them for the appropriate thing down the line. And judges know that you've just satisfied the test there. So when they actually say, address me on American cyanamide, that can sometimes be, I've got to write a judgment here that might be a bit controversial. And, especially in family proceedings, look, if I don't say that I've considered every conceivable point, the unrepresented other side might think it's just a stitch up between the lawyer and the judge. So I want you to go through it so I can address everything.
And just, we go on mini tangents sometimes, but another little thing that's come up in practice that some of my clients have struggled with is when you're in court and you're having to explain these legal tests to a court. And one of the comments, all virtually word for word or paraphrased, was, how come the judge doesn't know that already? Well, there's two things here. One is the judge probably does know that already, quite likely, I'd have thought. But two things. First of all, if they do know that, they still have to apply it, meaning they still have to consider the arguments and consider the test and show for the court record, I've considered the first limb of the test and my decision is this based on these facts. And then as to the second limb of the test and so on and so on and so on and so on. But, and that applies as well, by the way, even when the judge will put to the other party and say, what have you got to say about this? Persuade me that I shouldn't do this. And sometimes the other side thinks there's actually a cat in hell's chance of actually persuading the judge when we know there isn't. But the judge still has to consider it, so the judge will still consider it. The second reason, which actually, clients are quite surprised by, but it still happens. You mentioned the other day, Elle, about a judge. This was off air, I think, about a judge saying, I'm now reconstituting myself as a different type of judge, circuit judge and county court judge and so on.
He kept on being a district judge and a circuit judge because of the way the proceedings have proceeded. And it was sort of
because there's different powers of each judge, you see. So, but that's true as well between family divisions and civil divisions, and even to an extent criminal divisions. I think quite often family and criminal judges move between, and family and civil very often move between. But you see the books, I can never point properly because it's mirror image. Those books there, the red one at the bottom is the criminal book, and the top two are the civil books. But there's another red one, which is the family book. There's a blue one for something else, and so on. They're all different procedures, and that's not just case law for the law itself. These are the procedures: the civil procedure, the family procedure, the criminal procedure. And so each judge doesn't necessarily know everything about everything all the time. So if you, as I have, had a civil judge in a family hearing and said, tell me what the law is on this point so I can decide what to do. And you have to start essentially from the beginning, and we're not being disrespectful, but educating the judge on what the law is, because said judge has sat in for someone else that was taken ill or whatever it might be and hasn't done family for 10 years maybe. So that's the other reason why. Anyway, tangents. But you're talking about...
I know people like these little background stories of life at the bar. I can tell you this.
Absolutely,
I had managed to have a decent day. Now, because of the way I'm going to tell you this, because of the way criminal legal aid worked back in the day, and it's still the same because it hasn't gone up in 17 years, which is why it's like on strike effectively. But there was an advantage. If you could get a jury sworn before lunch, then you got like a whole day's pay, effectively, even if you then had to go home. So if you just said, well, I'll swear a jury and then we'll, so we've seized our jury and then everybody can go home. We would sort of beg them to say, can you swear them at 1 but send us home at 2? And I actually came back that actually managed to persuade a judge to do that for reasons, sort of legit reasons, but we were like, phew. So I meet a friend in the pub, and he's with another friend. And I started going, how'd you get on at court? We're chatting. How'd you get on at day? I said, yeah, it's great, because we had, we were in court, and I did this, and we got let out earlier. I was out by 2:10. I said, how'd you manage that? I said, we had one of these, and I used a phrase. I said, we had one of these something civil. We had one of these civil guys sitting as a recorder. Didn't have a clue. It was great, fantastic. Anyway, I'm sort of chatting, and it's like, this is Alan, blah, blah. I said, who's this? And he goes, and he introduced me. He said, hello, what do you do? And he goes, my name's so-so. I'm one of those idiot civil guys who sits as a recorder. And he actually said, I've wondered why you always do that. He said, I've had that where you've been saying, can we swear a jury now? He said, well, shouldn't I just swear them tomorrow? When we start the trial. No, it'd be better if you swear them now to, so we keep them and don't lose one. And that's the way you could survive at the bar. Honestly, it's like Mad Max 2 Thunderdome at the bar these days. You literally, because they will do everything they can not to pay you, as we've said before about saying, those 20,000 pages you read, you didn't need to read them, so we're not going to pay you.
Yeah, the other one is if the opponent says, well, I'm just going to make one amendment to the order, if that's okay, and then puts it to the judge, and the judge says, yes, that's okay, I'll make that order as well, and turns, if you draft that order, agree it between counsel, and then the other thing is, if it's legal aid, obviously, can I approve the extra time for considering the order? So it's, everything takes time, right? Otherwise, you've got to read it, you've got to address your mind.
Otherwise, you are literally working for free.
Otherwise, you're working for free, absolutely.
In criminal legal aid, it's sub-minimum wage anyway. So to sort of say, can you do this document? Okay, it might only take you an hour to put together, but that's an hour you're working for free.
It's an hour,
so,
indeed, yeah.
But that's back to the sort of just the general principle. Judges obviously get qualified at different levels. A lot of judges are part-time now, and in civil proceedings we call them deputy district judges. In criminal proceedings we call them recorders. And they are part-time judges. You agree to sit for 20 or 40 days a year or whenever they need you, and they pay you on a daily basis.
The same powers, though. It's not like they have half the power. Like, again, another thing I've had people misunderstand, like, a deputy district judge is not someone that stands in for a fully qualified or a full-time district judge is a full-time district judge, and a deputy district judge is not a full-time. But it's not as though they are just the deputy, lower in ranks and lower powers. They've got exactly the same powers as a regular district judge.
Yeah, that's the thing. Judges get ticketed, as they call it, for certain types of offence. So if it's a sort of offences of a sensitive nature, they have special training and they are ticketed to do those sorts of crimes.
Human rights and things like that.
Yeah, human rights, some sort of, certain types of violence. When you get your murder ticket, that's something that judge friends go, I've just got my murder ticket. But as you've said, generally speaking, once a judge is on a particular level, all judges are equal. There's a very rare example of a case recently, which was interesting, that in deciding which previous decision to follow, a judge, because there were two conflicting decisions, the judge went, the judge who made that is a bit more experienced in that area of law and had been sitting longer than the other guy, so I'm going to go with them. But technically, that shouldn't be a factor because they were sitting at the same level. But having said so, I've seen this go the other way, you see, because there's always... the difference between real life and law school. In law school, you are taught that the courts operate in a strict hierarchy and the decisions of higher courts are binding on lower courts. In real life, county court judge, I think the Court of Appeal was wrong on that. Just like, I'm going to do something different. But I've seen a case where in the High Court, they have a special type of judge called masters, many of whom are women. And what they do is they do all the procedural stuff, and they play a very important role because High Court litigation is hideously expensive and complex if you don't keep a rein on it. And they get involved very early, and they will set cost budgets, they will make preliminary decisions. They can do summary judgment applications, so they do actually decide things, semi on the facts, although summary judgment is sort of on the law. It's like assume all the facts are correct, who should win.
Yeah.
They play a really important role, but effectively they're the sort of they're the admin people and stuff. But I've seen there are cases where high court judges, because sometimes masters will make decisions on admissibility or procedural stuff or strikeouts. And then people will go to the High Court and go, well, that master's wrong, and effectively they're just, admin and stuff. But High Court judges, very senior High Court judges, have sort of said, I will defer to Master Yoxall on this, because he's been doing this like best part of 25 years. And he knows a lot more about the procedural stuff than I do. So even though technically in the hierarchy I'm way up there, I'm just going to go with what he says because he's got more experience. It's a bit like, how in special forces, the ranks go out the way. It's who's really good at what we're doing at the moment, you're in charge. This is, we need somebody who's really good at swimming, or somebody who's good at radio, or somebody who's good at shooting, you're in charge. Even though I'm technically the captain or the sergeant, but Private so-and-so is running the show for the next 10 minutes. And that happens in the court as well. But anyway, shall we segue back to, so you've seen how it works, and just to get back to this confidentiality thing, imagine a situation, and I'm going to say, this is a little puzzle for people maybe in the comments, and remind me I've got my hearsay puzzle. That
we can do a poll if you want, Al.
Yeah. Okay, here's the situation. As we have said, can't get an injunction in defamation, can get an injunction in confidentiality. Your housekeeper, who you've used, because you're a celebrity couple, your housekeeper, who signed a contract saying duty of confidentiality, is now going to the press to do a tell-all story about all the shenanigans you got up to and they saw during the few years that they worked at your house.
Because they must have seen a lot.
Everything they say, you say is untrue. You say, actually, none of this is true. Because they're saying we're neglectful parents and we run a terrible house and we made her do all the work and treat her like a slave. That's all nonsense. It's not true. Can you get an injunction to stop that being published?
All right, let's put that in the poll. Can you get an injunction against your housekeeper to maintain silence? And let's just autocorrect injunction. Yes or no in the poll, please. Yes or no. It's nice and straightforward response. Yes or no. Do you think you can get an injunction against your housekeeper to maintain their silence? They're about to go to press with everything they've seen behind closed doors, as the phrase goes lately. Everything they've seen and heard, but you say it's all not true. You're public figures. You've got all this information that your housekeeper could well be privy to, all the arguments, all the slamming of cabinets and that sort of thing that did or didn't happen. Your housekeeper's about to say. Let's see how many we've got. We've only got 30-something votes. Let's wait for how many got on the view. We've got about 400 of you watching. Let's go for at least half of you, so at least a couple of hundred votes, please. Super injunction, is that a qualifying question? Well, super injunction is. I'm
sorry, super injunctions are different, and we can talk about this while we're getting people
different.
A super injunction is where even the existence of the injunction is kept confidential, because the idea being that the mere fact that you can identify the parties and there's an injunction in place defeats the object of the injunction. Classically, they're given in blackmail cases. Sometimes they will be completely secret. Nobody can even say this injunction exists. More common regime, because people were challenging super injunctions, especially the press, was anonymizing them. So people could see the reasoning behind them, but they anonymized any identifying information. And remember all those XYZ versus so-and-so cases and all those alphabet soup cases. And somebody actually said that. They said this year's Supreme Court of Appeal docket looks like alphabet spaghetti because it was just loads of, they were very en vogue at the time. And then, of course, because of football cases, people would be chanting who it was on the terraces and things like that. But yeah, that's so a super injunction is where it's not just anonymous. There can be three things. There can either be, here's an injunction, all the parties are identified, and all the issues are there in the public judgment. Because nobody cares about whether I'm trying to stop Dan chopping down my tree. If it's something I'm trying to stop somebody doing a kiss and tell book, we could put it as ABC versus DEF, and ABC is a celebrity and DEF is somebody they met in a nightclub, and this is what's happening, and they want to publish this book, and we say, confidence, the secrets of the bedroom, it's all confidence. They can do it, but it could be something. Let's say it's a blackmail attempt. Or something, that like a company is doing this and they're being held to ransom.
Pay me more, I'm going to the papers. Yeah,
and the description of what they have done. This is to stop somebody doing something, and it's the thing you try to stop identifies or narrows down. We do what we call jigsaw identifications, and not all the information here, but adding that bit of information to this little bit of information, a bit of googling here, I can work out who it was. Those are super injunctions, and like I said, I actually got one, and I told you I was really annoyed about it because we had to do it in London. I was down here, and we had to instruct counsel in London because we needed somebody to run to the RCJ, the Royal Courts of Justice in the Strand. So get round there, find just whoever the duty judge is, and get this injunction. And I had to sort of instruct somebody in London to do it, and then the person in London says, "Oh, it's great. The judge just said he'll do it by telephone." So, I could have done that, and we need to pay you, and I could have kept the money. So I was really annoyed about that. It's like, because this is before everything. Because just to let you know, you can get a judge, High Court judge, 24 hours a day. I'm not going to publicise the phone number here because the relevant judge might murder me. But there is a number available, and this happened a lot in.
Had to use it.
We can use it. It is publicly available. You can find it out there. But this happens a lot where I've got friends who used to do collective labour law. They'd act for unions, and what would happen is there's about to be a strike. The relevant, the train company or whoever, the government would go and say, "We want an injunction to stop the strike," and they would be stood in the hallway of some judge in a dressing gown, rubbing his eyes, going like, "What are you doing here?" It's like, "Oh, they didn't do the ballot properly, so you got to injunct it." Literally, they just turned up on the judge's doorstep to do it. So, this is all the secrets of. In a way, this is more interesting and exciting, I think, than the sort of regular stuff we know about. But anyway, do we have enough people for our poll now? I've rambled.
We have just shy of 100. I think we've got a lot of either abstemiers or people not quite sure what to think. So we'll end the poll. But it's fairly narrow, actually. But we've got a narrow yes at 57%, thinking you can get an injunction to silence your housekeeper.
Well, that's interesting, because the appeal court was similarly, they found it a very finely balanced exercise. Courts generally don't like to say, "Oh, this was a difficult decision," because then it encourages appeals. It's like, "Oh, the law is clearly this." But they said the same thing, because they said, "Well, look, yeah, it's a breach of the confidence. But there's no confidential information there because it's false. It's false information. So how can there be any confidence in the false information?" And they said, "Well, there's enough true information in there as to how we take our kids to school, where they go to, what our domestic regime is." They said there's enough genuinely true confidential information that should all be blocked, and you can't really cherry pick. I mean, it could have been up to the other side to come back and say, "All right, we'll exclude all that, but we'll just leave in the defamatory stuff, and you won't be able to get the injunction." So it was very fine, but actually they did grant the injunction in that case. But they did say that every case will turn on its own facts. So if it's purely defamatory, it might be, well, publish and be damned, and you can just do what any defamation person says and say, "This is not true."
And one of those factors, doubtless, in most... I'll just bring it back on screen, from Christy Ford... did they enter an NDA with regard to the employment? Well, obviously, hypothetical question because we're not speaking about anybody in particular, but almost inevitably, anyone in that position would, at the very least, even if it's through an agency, there'd be some kind of contract. But even if there were not a written contract with a written section of confidentiality and non-disclosure and so on and so forth, even if it's not written down, there would be an inferred or an implied term at the very, very least, because it would be perverse to say that, well, you can come and do the work, but then, just blab anything that you see to everybody and anybody when you leave the room. That's obviously not right. So there'd be at the very, very least an implied term. You'd have to argue it more robustly if it's not written down. If it's written down, then fine. That would be certainly a strong point to consider for the injunction. But regardless, there'd be an implied term. So yes, it'd be one of the things to consider.
In that case, there was an explicit, because these were celebrities, there's an explicit non-disclosure. So they applied for the injunction, not just in confidence, but for breach of contract. But obviously, breach of contract, it's like, well, it's breach of contract, damages are an appropriate remedy. You just get your wages back. You'd have to pay your wages, or you can garnish the profits on the book, something like that. It was a very, very finely balanced exercise, because one reason to breach a confidentiality agreement, whether it's an NDA, is there's this idea that confidence will not protect iniquity. Now, let's say somebody does an injunction saying, we will not discuss anything that ever happened in a particular, work relationship, including all my puppy strangling. And you go, okay, everybody's going to keep quiet about that. But then somebody goes on there and says, I have never strangled puppies in my life. You say, well, actually, that even though I am banned from talking about that, the fact that you are now putting a false narrative out there releases me from my duty of confidence, because correcting a misrepresentation can be a defense to a breach of confidence. Because the whole point is that NDAs and confidence isn't there to shield misconduct. I mean, people do use it to shield misconduct.
Just like without prejudice isn't there to protect threats. I've seen letters before now saying, without prejudice, we're going to sue you for this, this, and this, and these are the reasons why. And if you don't do it, we're going to, send the boys around, kind of thing. Yeah. There was an inherent threat within the letter. And at the bottom it said, and of course you can't tell anyone about this because it's without prejudice. Well, of course that's not true. I mean, we very often say if it doesn't make sense, then it's probably not right. And that's one of them. So without prejudice. There was an interesting question here. What about information that could be detriment to others, such as an employment status, etc.? I assume you mean other people's employment status. But I mean, there's an interesting question there, because it depends whether the employer has standing to bring this on behalf of somebody else, because they probably don't. If the person says, well, I'm going to go and talk about this other thing about someone else, I suppose it depends whether they found the information out because of working at this place, and then that person by implication has a duty to protect that information. Then it's a difficult one, isn't it, Al?
Some information you'd be able to bring sort of a data protection claim. You'd have an individual right if it was confidential or sensitive information. But yeah, I see what you mean. If it's just something like, somebody's salaries being out there, somebody's leaking what everybody's salaries are, and you don't want people to know, it becomes, do you have a claim in your own right? And it's, do they owe you a duty of confidence? And we get back to Dan's thing about, if there's no contractual thing, you look at the nature of the information. Is this information you would normally expect to be kept confidential? And everything's a matter of fact. Everything's a matter of fact.
And in most cases, it probably would. In most, and what colour the walls are. I mean, there's nothing really turns on that. It doesn't really matter if I've got blue walls in the bathroom or whatever. Nothing really turns on it. But if there's if I'm representing a certain client and the cleaner finds out, for one way or another, because you can't, we are under we have a duty of confidentiality with all our clients and so on and so forth, but only that which is within a reasonable protection of all of that. So they shouldn't see any of that, but if they did, that's something that they shouldn't be telling anybody, for example. So I mean that whether that's within their contract or not, that would go without saying. There's a quality of confidence about it, and sure, they shouldn't be saying any of that.
Okay, so just to bring this back as well to sort of vaguely expectation management, because I did mention this public interest point about the Pendleton case in that appeal and things. So we've talked all about why public figures are treated differently. And when they are not treated differently. And basically what the Amber Heard appeal is going to be about, we discussed the Pendleton case, that's the poor peanut allergy girl. What they're basically going to argue and say is, well, okay, even if Pendleton is correct, because it's going to be very hard to attack Pendleton, because I'd given it about a 10% chance of success, and then loads of people in the comments said, you do know all the judges in Pendleton and now sat on the appeal court. So it's like you'll be arguing, those judges all got it wrong. Oh, that was you, wasn't it? That's a really hard argument. So what they're going to do is they're going to try and we're guessing here, but I think this is a 99.9% certain guests, they're going to say public figures should be treated differently. So even if Pendleton is correct, then it doesn't apply to public figures. And that's, again, going to be a hard argument, because we come back to this idea of, well, why are you in the public eye? Let's say, for instance, that the Pendletons had been celebrities. Let's say they're a celebrity couple. Is the law going to say, well, it's okay for everybody to falsely accuse you of murdering, killing your own child, even though that's coming from the people who actually were responsible? So why you're grieving parents, but because you were in a couple of movies, your pain doesn't count? So this whole point about arguing why public people should be treated differently. I mean, I think in that case, the fact that Amber Heard has said, I've put myself forward as a public spokesman on this very narrow issue, that definitely brought it in. Johnny Depp is a public celebrity, but in terms of, what interest do we have in knowing about his private life? Now, what you usually get with public people is they go out there, they do press releases, they put themselves up as role models, they go in the public eye and they sell themselves as part of as being nice people. So therefore, but let's say you have some completely misanthropic actor who never went out, hated everybody, never responded. If you sent him a fan raid, just went, I hate every go. Could you really sort of say, well, we'll bring their character into it? Because they've never really put their character out there. They've never claimed to be anything special. But with, this is the whole thing with the treating the public issue. And just to say, a lot where this has been considered in a few other jurisdictions in the US, I think Florida's one, they've sort of said, no, we can't see any difference between treating public and private people. Because they're saying, yes, the reason we do treat public figures differently, but the protection for people writing about public figures is the requirement for malice. So that is your defense. And that gives you the freedom and a bit more leeway than just writing about your neighbours. But at the same time, it doesn't make a difference whether it's defamation by implication or straightforward defamation. The requirement of malice is the protection to defendants. And I just can't see why they say, well, there should be an extra hurdle to get over when it's defamation by implication. Because the whole point of defamation by implication, and the rationing in Pendleton is saying, it doesn't make any difference whether it's literally true or not. We just look at meaning. So I like I say, and I'm really looking forward to seeing how they put this ground in the appeal, because it's such a hard ground to put, because effectively all you've got to say is celebrities should be treated differently. That's pretty much the height of it. And
that's really the conclusion, isn't it? That's the rather and anticlimactic conclusion to the video.
Well, yeah, I think that's really going to struggle. I mean, that is, so that's the thing. So we've done that because, like I said, people were asking, and a few comments have been raised. And there's another point that people keep raising about sort of defamation by implication, which is not naming somebody. But I've done a little short video on that, and Dan's actually edited it and everything. I think. Unless you don't want me to, because it's a terrible video. It looks like I've been shot on night vision. I thought it's quite good. But yeah, that's it. And I don't know if we've got here. Shall we save hearsay for another? Shall we set a question for somebody, for people, and then they can think about it for the next video?
Sure. Go on then.
Okay. Here's a scenario I want you all to go away. This is your homework. Okay. Dan and I are out, and Dan, being more observant than me, sees a bank robbery, and he sees the getaway car screech away, and he yells to me, he goes, "Ow, ow!" And I'm oblivious and go, "What?" And he goes, "Quick! Remember this number," and he shouts the registration number out to me, and I go, So I just write it on a bus I just write on a bus shelter window with my finger and stuff. But in the sea, and I've written it there, and it's starting to evaporate. Luckily, somebody was passing, and they have a mobile phone, and they say, "I'll take a photograph of that number on my mobile." Yeah. Click, and they take that photograph. And anyway, eventually the police turn up and say, "Did anyone get a look at the car?" And it's like, "What's the number?" And it's like, "I can't remember." But the girl goes, "It's on my phone, officer." And the officer goes, "Oh, that's handy. I'll just make a note of that."
Write it down, yeah.
Right. That gets to court. And the officer goes in the witness box and somebody says, "Officer, what was the registration number of the getaway car?" Can he say what it was? And we'll leave that for you as your little intellectual legal exercise. Is it admissible? If it is admissible, how is it admissible? And if it isn't admissible, where does it all go wrong? So there you go. So that's your homework.
fascinating question, and we'll leave it there. And I think very interesting question to leave on. And hearsay and all of that is one of these very big, deep topics which I think we're going to enjoy talking about. So thank you all for your kind attention. Thank you for watching. And there'll be another video coming up, as Al just mentioned, very shortly, probably later today. But in the meantime, leave any questions and comments, and we'll be back for more. So thank you for watching, and we'll see you soon. Take care.